Hello everyone, my name is Rhea Blaza and my topic in this video will be causation and remoteness under the tort of negligence. What is causation? So causation of harm says that even if it owed a duty of care and breached the standard of care, the defendant will not be held liable unless its carelessness is caused the plaintiff to suffer a loss. It simply means that once a duty of care was established and it was found out that it was breached by the defendant, we must look at the action done by the defendant if it caused the harm or loss. So causation is often divided into two parts: factual causation and legal causation. So the but-for test generally determines whether the defendant's carelessness in fact caused the plaintiff loss, and the remoteness test determines whether, as a matter of law, it would be fair to hold the defendant responsible for the plaintiff's loss. The issue of causation is usually decided by the number one but-for test. So but-for test requires the plaintiff to prove that they would not have suffered a loss but for the defendant's carelessness. It's based on a simple question. But for the defendant's carelessness, would the plaintiff have suffered the same loss? So if the answer is yes, the plaintiff would have suffered the same loss if the defendant had not acted carelessly. Under the resulting law, the defendant cannot be held liable. But if the answer is no, the plaintiff would not have suffered the same loss if the defendant had not acted carelessly. The defendant will be held liable. So there are four principles to consider about causation of harm. Number one is the balance of probabilities, which means that the plaintiff required to prove at least 51% chance or higher that the defendant, number one, owed a duty of care, has breached the standard of care, and has caused the plaintiff to suffer. Number two is the all or nothing. It simply means that if a court agrees that the defendant probably owed a duty of care or the breach of standard of care and caused the plaintiff loss, then the defendant is liable of all the plaintiff's loss. And this is true even if, for example, the court thought that there was only like 60% chance that the defendant was responsible for the plaintiff's loss. So the rule works the other way as well. If the judge finds that the defendant probably did not negligently cause the plaintiff's injury, then the plaintiff will not receive any damages at all. And that is true even, for example, the judge believed that there was just like a 40% chance that the defendant was responsible for the plaintiff's injury. The third one is the cause, not only the cause. The plaintiff must prove only that the defendant's carelessness was cause, not necessarily the only cause of loss. Suppose I suffer from back pain, was mostly caused by my bad posture, but the fact that you push me you push me downstairs, I'm entitled to receive 100% of my damages from you. So number four, we have the multiple defendants. Joint and several liability means that all the defendants are liable, but the plaintiff is entitled to decide how much compensation will be collected from each defendant. So joint liability means that all of the defendants are liable for some tort. Several liability means each defendant is individually liable to the plaintiff for the entire amount. So I have two cases on this topic, one for causation and one for remoteness. So I have selected these cases because I believe it offers a valuable insight for my future aspiration in business context as I aim to become an entrepreneur. So my first case will be Barnett versus Chelsea and Kensington Hospital Management Committee, 1969 1QB 428. So the highlight of this case is Mr. Burnett went to hospital complaining of stomach pain. And the doctor on duty believed that there was nothing seriously wrong with the patient and simply told him to go home and sleep. The man later died of arsenic poisoning, and his widow has shown that the doctor, number one, owed a duty of care to her husband. Number two, carelessly failed to realize that her husband's stomach pain were due to arsenic poisoning. So the judgment in this case was hospital was not liable using the but-for test. So the court ruled that the hospital was not liable for the death of Mr. Burnett. In the basis of this argument was the but-for test, that even if Mr. Burnett had received care in the emergency room that morning, it would not have saved his life. The next one will be remoteness. So in negligent cases, the main question is whether the harm suffered by the plaintiff was something that a reasonable person could have expected from the defendant's carelessness. When we say reasonably foreseeable, it doesn't mean it had to be a probable or very likely, just that it was a possible outcome that wasn't too unlikely. Moreover, if the harm suffered by the plaintiff could have been reasonably anticipated, it doesn't matter if the specific way it happened was different. So remoteness test determines whether, as a matter of law, it would be fair to hold the defendant responsible for the plaintiff's loss. So there are three things that we have to consider in remoteness. Number one is reasonable foreseeable. And number two is thin skull rule. So thin skull rule case occurs if the plaintiff was unusually vulnerable to injury. Thin skull rule makes the defendant liable for the plaintiff's injuries even if the injuries are unexpectedly severe owing to a pre-existing yet stable condition. And number three is intervening act. It is an event that occurs after the defendant's carelessness and that caused the plaintiff to suffer an additional injury. Suppose you carelessly broke my leg. A week later, I suffer another injury, either because I fell while walking downstairs on crutches. As a general rule, however, liability will be imposed if your original negligence increased the risk of my subsequent injury by causing me to use crutches. You made it more likely that I would fall. So moving on to my next case, which is Hughes versus Lord Advocate, 1963, AC 837 HL. So the highlight of the case was the post office workers were working underground and left the manhole unattended, surrounded with kerosene lamps while on break. Plaintiff Hughes, an 8-year-old boy, was playing at the unattended site and knocked over kerosene lamp, which resulted in a huge explosion that threw him down the manhole. He suffered severe burns and sued defendant. The defendant argued it was not the proximate cause of the injuries. The higher court disagreed and found for plaintiff on appeal. So the issue here was whether the defendant can be found liable for negligence where the manner of cause of the injury was unforeseeable, but the injury is the type that was foreseeable. So the decision outcome was the House of Lords ruled out in favor of the plaintiff, highlighting that while it was not reasonably foreseeable that a drop lamp in a manhole would cause a large explosion, it was foreseeable that someone could get burned by unattended paraffin lamps. The focus on foreseeing the type of damage rather than specific outcome as expecting the exact harm would set too high a standard. This case underscores the importance of foreseeing general risk rather than specific details when determining liability for negligence. So in this case, we can see that safety precaution was not enough. So if they could have put um, more barrier or put back the manhole cover, it could have helped avoided the explosion that results the injuries to the 8-year-old boy. So in my conclusion, understanding causation and remoteness can help future business leaders by showing them how action lead to consequences and how far their responsibility extends. By grasping this concept, leaders can foresee risk, make better decisions, and avoid costly errors. Causation helps link negligence to harm, while remoteness sets boundaries on losses that can be claimed. This knowledge guides leaders in assessing liability, predicting potential harm, and defining the responsibilities, ultimately helping them protect their businesses from legal and financial risk. That's all, and I hope you learned something from my